Notice of hearing and motion for withdrawal of counsel. Okay, I just went through that one. Notice of arraignment. All right, now they're going to bring me up to my arraignment. Remember, there's lines of defense there at your arraignment. Information. Information. Let's see now. I think we've already sent to you Blackstone's commentary on informations now, haven't we? That informations were used to shamefully enrich the crown. Remember that? Refer to that every once in a while. You know, every time I see an information, I walk into court, and this, I get tired. You know, I walked into court yesterday, and I watched about 10 felony arraignments. And this judge would sit up there, now I have an information in front of me, and now I have an information in front of me charging you with. I have an information in front of me, and it says that. Do you want to waive the formal reading of the information? No, Judge. Boy, when I'm in there, would you read that so that we could see where we're at? Information. You know, it seems to me that Blackstone had something to say about informations, and boy, I'll sit there and preach him a sermon on informations. Take a look at informations. Find out where they came from, what they're used for. And, by the way, what happened to the grand jury indictment, Judge? That's kind of what I'm interested in. And all of these jurisdictional defects that you're going to come up with when you take a look at your motions in here, there's some of them in here. I wrote in 8 or 10 jurisdictional defects. In fact, I have a motion on that very subject of jurisdictional defects. And so we're on lesson 19. Let's put that in here at this lesson. Jurisdictional defects, there's 8 of them. Stick that into your binder and bear that in mind. Every time you're charged with a crime, take a look at your state constitution. Here in Idaho, for all of you that are students here in Idaho, prosecutions by indictment or information. So there are states that have indictment by information. There's nothing wrong with indicting Boise Cascade with an information. I don't have a problem with that. It's just that I'm not a corporation. No person shall be held to answer for any felony or criminal offense of any grade unless on presentment of indictment of a grand jury or on information of the public prosecutor. Well, we don't have any public prosecutors. We have prosecuting attorneys. So let's put that one in here at lesson 19. That's a good point. Good time for you to get those 8 jurisdictional defects. All right, informations then will be covered in that. Number 15 is 18201, persons capable of committing crimes. Take a look at that because in Idaho, it requires 2 items to have a crime. You have to have 2 indicia. You have to have an act, and you have to have intent. Okay? Take a look at the word crime, and you'll find that it requires an act with intent. Look at malice, some of these legal terms. Well, now, if you've got the driver's license, you see they don't need any intent. Your intent to break the law, remember the license is permission to do something that would otherwise be against the law. So they're licensing crime is what it boils down to. You ought to ask the judge sometime, oh, I see, you're licensing crime. Gee, Judge, can the state license crime? If the state can license the crime of driving, can't the state license the crime of robbery, license the crime of larceny, license the crime of murder, license the crime of rape? In other words, rape would be lawful and legal then, wouldn't it? If the state were to issue licenses to rapists, they could go out and rape lawfully, couldn't they? Well, now, wait a minute. Are you telling me then that your common sense would tell you that the state cannot license crime? Well, if the state cannot license crime, then it's obvious the state can't license driving, because driving's got to be a crime if you're going to license it. The definition of a license is permission to do something that would be a crime. So what we're talking about then is that's obviously redundant or ridiculous. So what we're saying is that when you're engaged in trade, commerce, business, or industry, it's a crime to conduct those trades, commerce, business, or industries without the proper licenses and regulations that go along with them. And therefore, when you're licensed or when you're incorporated, you don't have to prove intent, you just have to prove the act. The intent to commit the act is manifest in the license or the contract. It's just that simple. But when we're talking about crime, you've got to have intent to go along with the act. Now, where is that intent? So check that out in your state statutes, rules of procedure, or in Idaho it's 18-201. Notice and demand for right sua sponte. That's an old common law motion. And the purpose of that common law motion is to make demand upon the judge to inform you of your rights as they become due to you. For instance, you're going through the trial, or a motion hearing, and you're ignorant, you don't know, and you're not a lawyer, you haven't been to law school, and you're appearing in propria persona. Now it comes time for the prima facie break. It's incumbent upon that judge then, based upon this demand for the judge to show you your rights, and that word sua sponte means right now. Timely. Failure to assert a right timely waives the right. I don't want to waive any of my rights, Judge. I demand every one of them. I only found one judge so far in Idaho that knew and understood what right sua sponte meant, and I remember I went to court with that guy, and every time there was a right, he'd say, "Now, Mr. Gordon, hold it right here. The state has just rested their case. You have a right now, pursuant to the rules, to challenge the state's prima facie case. Would you like to do that at this time?" And I sat there and went, prima facie, what does that mean? Mr. Gordon, I'm not your lawyer, and it's not my responsibility to teach you the law. I'm simply instructed by your notice and demand for your right sua sponte to inform you of your rights when they're due and when they're available so that you won't waive them. And you have that right now. Did you want to exercise it? Well, no, Judge, I don't even know what it is. All right, Mr. Gordon, we'll break for lunch right now. Bang. He did his job. He told me I had a right and it was due right then and there, and I didn't know how to exercise it. It's not the judge's responsibility to teach you law or to manage your case, but it's absolutely necessary and imperative and incumbent upon him to tell you of your rights pursuant to the rules when they are due. Okay? So make that notice and demand. And then when they fail to tell you of your rights, assuming that you can identify the rights after trial, remember, if you can't identify them, you can't claim your rights, then they're waived. But if you were to come up with a right or two after the trial, did he tell you that you had a right to challenge the jury, that you had a right to write a motion notwithstanding the jury verdict as an example? If he failed to tell you about that, then that's an appealable issue. He didn't notify me of my right sua sponte. Notice and demand for counsel of choice. And then the brief in support of notice and demand for counsel of choice. I'm going to spend a couple of minutes on that. In fact, that's number 18. All right, let's take a look at number 17, which is a notice and demand for counsel of choice. And I'm looking at this binder here. I notice that number 18 is missing, so in this lesson number 19, we're going to include that missing brief, which is the brief in support of notice and demand for counsel of choice. And that brief, even by itself, is about 30 pages. It's 26 pages long. And in the time that I have left in this lesson, I obviously don't have time enough to sit here and read it to you. I'm going to tell you how important this is. Now remember, early on, I told you that you needed to read 100 cases from the search and seizure law report. Counsel is probably the most single important club that every pro se has when he walks into the courtroom. And the reason is money. You see, the bar associations have an absolute legal monopoly on stranglehold on those courts, and they want to keep it. And they don't really care about law and order and justice. I haven't talked to very many prosecutors or lower court judges that are really interested in constitutional rights or law and order. They're interested in protecting their own paychecks and protecting their monopoly. And in the process, if they let me go, they may hate me, but they'd sooner let me go than to capitulate and let some layman come into the courtroom and practice law, that is, practice to their way of thinking. So we discovered this a couple of years ago. In other words, when I noticed they were wearing their counsel feelings on their coat sleeves, I recognized that that was their Achilles heel. And any time that you find a weakness, any time that they shy away, that's like the communist philosophy. You probe until you hit mush. And every time you hit mush, you probe deeper. When you hit steel, you back up. So I always probe and I always push them into the corner. We'll find out where their steel is. I'm prepared to argue the counsel issue to Washington, and I haven't found a single prosecutor or judge that's willing to do that yet. So at this point in time, you need, if by this time you don't know and understand the counsel issue and understand it well, don't look at lesson 20 until you understand counsel. You should win every case that you go into court with on the counsel issue alone. And that counsel issue, if it's the last issue to be listened to or argued by a court is going to be your winning issue. In Idaho, they are beginning to let citizens speak for other citizens. Now, we still don't have effective counsel pursuant to, I think it's Ferretta versus California, and Zerst, I think, versus California, and Powell versus Alabama. But we're beginning to crack that egg here in Idaho, and it'll take a year or two for you to do that wherever you are. And in the meantime, you'll just rack up win after win after win. But I'm amazed at how many people I talk to on the counsel issue, and I can talk to a person in about 5 minutes. I can tell where his level of understanding is. And I'll ask him, I say, okay, now have you got your counsel issue? You know, oh yes, Mr. Gordon, yeah, I'm all ready. Okay, now are you prepared to argue counsel? Well, I hope so. What the hell do you mean you hope so? You're either prepared to argue it or you aren't. What are you, half pregnant? You can either walk into the courtroom and you can simply argue this motion in this position. There's your legal quotations book. Do you know about 201, 202, 203? Are you familiar here with counsel of your choice and counsel beholden to your adversaries? Well, I think I've read some of those. Oh, baloney. You're not prepared to argue anything. And until you get to that point where you're prepared to argue this particular issue, you might as well just stop right here and get competent. You know, the counsel issue really came to a head in 1968 with Miranda versus Arizona. And let's see if I can pull out a Miranda book here. Yeah, I guess I can. You take a look at Miranda. I'm just going to skip over here a little bit and see whether or not I can put my finger on it. And I claim that I can argue the counsel issue. And the Supreme Court came up with a nifty quotation here. I think it's on page 480, actually. Let's see if I'm right. 77, 78. Yeah, it's on page 479 is where it believes. Now it begins. Now I'll read this to you, and I want to show you here that the Supreme Court of the United States seems to understand law. It says, decency, security, and liberty alike demand that government officials shall be subjected to the same rules of conduct that are commands to the citizens. In a government of laws, existence of the government will be imperiled if it fails to observe the law scrupulously. So I'm reading this to the judge. I'm reading this to the court. Our government is the potent and the omnipotent or omnipresent teacher. For good or for ill, it teaches the whole people by its example. Crime is contagious. If the government becomes a lawbreaker, it breeds contempt for the law. And I'm contending, Your Honor, that it's time for this court and for this government to obey the laws. It invites every man to become a law unto himself. It invites anarchy to declare that in the administration of the criminal law, the end justifies the means would bring terrible retribution. And I contend that the end does not justify the means, and that I have rights, and I want this court to recognize my rights. Against this pernicious doctrine, this court should resolutely set its face. And that comes from Miranda versus Arizona, Your Honor, 436 U.S., and at page 480. Now, I contend that the government ought to obey the laws. And I'd like to bring your attention now to page 484 pursuant to this issue of counsel, Your Honor. On page 484, this court said that after passage of the Criminal Justice Act of 1964, which provides free counsel for federal defendants who are unable to pay, we added to our instructions. And if you look at the quotation, this was the instruction of the FBI to their agents. In other words, the FBI added to their instructions to special agents the requirement that any person who is under arrest for an offense under FBI jurisdiction or whose arrest is contemplated following the interview must also be advised of his right to free counsel. Would you please note that word counsel and not lawyer, Judge? If he is unable to pay, and the fact that such counsel will be assigned by the judge. At the same time, we broadened the right to counsel warning to read counsel of his own choice or anyone else with whom he might wish to speak. And that's the law of the land, Your Honor, because the Supreme Court of the United States adopted that standard and put in that Miranda case. When counsel appears in person, he is permitted to confer with his client in private. Why is this court denying me the right to counsel of my choice when the Supreme Court has been emphatic and adamant about that very subject matter time after time after time? Could it be that this court is of and by itself lawless? Is this court acting then in a capacity outside the law, and is it a law unto itself? And you see your argument there in front of the court. What is this? 1 Gordon 14:4? Baloney. Hell, I'm not smart enough to even come up with lines like that. And in this brief that I'm sending in this lesson, there's 26 pages in which Bob Hallstrom wrote this out, and he went through every single word and puts the definition of every word of the Sixth Amendment, not Sixth Commandment, but the Sixth Amendment into this brief. Anybody who reads this brief and can't understand the counsel issue is stupid. And if you're stupid and you can't grasp it after lesson 19, you ought to drop out right now and go back to Egypt and make bricks and gather straw and shut up. And if you can't argue counsel by now, then you're going to have to go back, and pick up. Now, if you're slow, like I am, I only read 237 words a minute. I'm one of the slowest readers there is. I went to the Evelyn Woods Reading Dynamics course one time, and I'm one of the few people that they said could not qualify to go to their school. That's how stupid I am. Incompetent. So, in my simple little way, I read 237 words a minute. They tested me. And I read everything on the page, including the page numbers, and when I get to the end of it, I think I can understand it. I don't understand much of the English language, only about 3%, but the 3% that I do understand, boy, I'm hard on. I'm tough. Counsel is the most powerful argument you've got, and it's the one issue that they don't want to face up to. And you talk about a line of defense, that's like, having 500 ships out there in the Navy bombarding the beaches. That's how powerful that particular issue is. And still, I don't rest on my laurels and say, well, I've got my counsel issue in, and that's good enough. No, now I put grand jury and informations and public prosecutors and etc. Item after item after item. Every defensive strategy I can think of, I'll put in there. But at this point in time, you should be thoroughly familiar with that counsel, because I can't overemphasize it enough. That's your Battleship Missouri with its 16-inch guns. That's the biggest thing you've got. And then right behind it comes grand juries and information. And then the jury issue of and by itself. I don't know if I've got that jury issue in here. If I do, read about it. If not, we're going to cover juries, and when I do, I'll send you all of those briefs and motions on juries. Okay, I want to run through here and talk to you about three more of these while we've got a little time. You got a motion to appoint a public prosecutor. Now, I don't know where you are, and you may have prosecuting attorneys, but when you walk into that courtroom, you want an executive officer over there appointed by the governor. He's got to be an executive officer that prosecutes you. Take a look at your state constitution and find out if it's what we've got here in the state of Idaho. He's a judicial officer. And so we've got two judicial officers in the court. You see the importance of claiming that the court is improperly set? Your Honor, I want to be tried here fairly. I want to have a fair trial. I don't want to be tried by my government in front of a government jury and by a judicial officer. I want an executive officer, and I'll defend myself with my counsel of my choice, and I want a neutral judicial officer to listen to the case. I demand due process. Okay? Motion to appoint a public prosecutor, motion to dismiss for failure of due process. Now we get into the jurisdiction briefs, and if you'll notice, there's a jurisdiction brief, an equity and supportive demand for dismissal. It's number 21. There are 6 briefs in support of that jurisdiction motion. They're not necessarily in order, I noticed in here. Whoever put this together, I guess that was me, shows his incompetence by not having his arguments laid out in chronological order. So you can blame me for that. But number 31, I notice, is jurisdiction brief, merchant at law in support of demand for dismissal. I I don't know what the second most important argument is. Maybe Bill Avery would say that it was jurisdiction. That was always his hot button. If counsel isn't number one, then I guess jurisdiction is. Jurisdiction is probably one of the most valuable, no matter what ranking it has. It is a club, like a baseball bat. Because remember, if the court doesn't have jurisdiction, it can't even move forward. So I'd say now at lesson 19, as soon as you get through with counsel, you better go through each and every one of these jurisdiction arguments in here and make sure that you know and understand those jurisdiction briefs and the article or the issue of the motion for dismissal for want of jurisdiction. Because in effect, what you're saying is the court does have jurisdiction if you've got the driver's license in traffic court, and if you don't have the driver's license, then they don't have jurisdiction. If you don't have the driver's license, they haul you into the traffic court, you got two issues, two big clubs, procedure and law. Because you see, you're not even a person who's required to be in that traffic court. Now, if you've got the driver's license, you got one big club, and that big club is procedure, because now they're probably going to deny you counsel, and they're probably going to deny you right sua sponte and a grand jury. They're probably going to deny you a number of things that you're entitled to. There might be some question as to whether you're entitled to a grand jury in an administrative matter, because remember, the traffic court is simply an administrative procedure just like the tax court. If you're a taxpayer, it's not a rights issue. If you're a licensed driver, it's not a rights issue. But there's still the rules of procedure, and the rules of procedure come under the Idaho criminal rules or the Idaho misdemeanor rules. And so even if you've got a driver's license, you've got rules of procedure that your public officials will not follow. You show me a court that follows its own rules and procedures, and I'll show you a court that is probably only the Supreme Court of the United States. I'm assuming that the appellate courts do follow and adhere to their own rules, but I'll tell you the magistrates' courts and the district courts don't. Well, they're just like people, they are people just like we are. They take the course of least resistance. They'll take the easy way. They'll prosecute by information as long as you'll cooperate with them and you fail to object timely. All right, so now you'll notice there's one other item in here. It's called an arraignment and plea. Now, oftentimes they'll enter a plea for you. Now, when that happens, I like to put it in spades so that when the Supreme Court of the United States takes a look at the case, they'll see that I didn't plea. That was the judge that pled for me. I challenge jurisdiction because the entering of a plea grants or confers jurisdiction on the court. Check that out in the dictionaries and you'll see that under arraignments and pleas that that's true. And it isn't true because I told you it's true. It's true because that's what the dictionaries tell you it is. So don't believe me. Check it out for yourself. That's why I like to put that arraignment and plea in writing, so that there isn't any misunderstanding. When this book gets to the Supreme Court of the United States, I want that court to understand and know what my position is and spelled out in spades. Okay, number 26, notice and demand of demand for venturing into number 12. Okay, there's your demand for a 12-man jury at the common law, and I think that there's a brief in support of that. Okay, I don't see it in here, so let's write that one down. We want the brief in support of notice and demand for venturing into number 12. You might as well take a look at the jury issue right now. You know, the jury issue is an important issue. It's another important big baseball bat or big club because we don't have juries anymore, and we haven't for a long time, and Red Beckman probably is the one person who has done the most in the way of research and writing books on that subject matter of juries. In fact, I think right now we ought to include that book from Red Beckman in this lesson 19 so that you'll have that if we haven't already sent it. I don't know if it's been out in some of these earlier lessons. And I'm not pushing Red Beckman's book, and I'm not, affiliated, and I'm, one of my key, I wouldn't say demand, but one of my key thoughts or ideas, one of the things that I try to impress upon students and others, that I don't attack other groups and other people. I don't care what they're doing their thing, and they're doing what they think is right, and everybody's entitled to their opinion. And I don't know whether this group or that group is good or bad or right or wrong, and I just don't attack them. I don't see any value in it. But then neither do I support or do I subscribe to them. So when I recommend a book, I don't want you to think that I'm promoting or that I'm endorsing anybody, because I don't endorse people either. I just like to tell you, when I read a good book and I see some truth or some understanding or some information in there, I like to pass it on. And so when you hear me mention other people's material, it's for that reason. Going on now to number 27, notice and demand for affidavit in support of the complaint, another technical move. Under the rules in Idaho, I'm entitled to that affidavit in support of the complaint, and if I don't get it, then I'm going to move for dismissal on that, and I'm going to put that in my appeal, and I'm going to say these people don't even obey their own law. They don't obey their own rules. And I'll go back to Miranda, and I'll say the Supreme Court said, we expect the courts and law enforcement agencies to obey the law. If there's one thing that I'm out preaching more than anything else, I think it's time for our courts and our police agencies to obey the law. That's what the Supreme Court said, and that's what I agree with. Not what I'm telling you, it's what I agree with. Number 28, notice and demand for dismissal for loan of jurisdiction. There's your jurisdiction. And then there's several briefs. There's rights in support of demand for dismissal, status in support of demand for dismissal, merchant at law. All right, now you'll notice jurisdiction brief, number 34, memorandum of law. Okay, all those go together on jurisdictions. Now you're talking about counsel, juries, jurisdiction. Boy, I'm telling you, there's three great big baseball bats. Haven't found a court yet that wants to address those issues. Why, they avoid that like the money issue at Article 1, Section 10. It's like the plague. It's like walking in, with the measles. Want to kiss me, sweetheart? I've got the measles, It's like saying, hey, I've got herpes. Nobody wants to get close to you. Boy, they want to get as far away from you as you can. And that's why I like to walk right in there with all these herpy briefs. All right, take a look over here at number 33. Notice and demand to dismiss for failure of the statute to identify the act or the crime. Take a look at that and read it. You've got to have an act that is a common law crime. Where's the corpus delicti? Okay? Number 35, notice and demand for a public trial and or hearing. 36, response to the defendant's motions. Oh, I guess my government responded. Respond to the defendant's motions. So I don't need to look that up. All of my motions are specious, frivolous, without foundation or merit. That's all they ever reply. And number 37, notice and demand for show cause hearing, and then I filed a order for return of my fingerprints. And by golly, they gave them to me. I got my fingerprints back on this case. And just goes to show you that they didn't even need to take them and that they didn't even have a crime. And so let me see if I can recapitulate here for a moment. I went through this lesson 9 now so that you could take a look at each and every one of these motions and put every one of those motions into your defense, because each and every one of those is a separate line of defense. Just like Almeida Sanchez, who had his one issue of the Fourth Amendment. Any one of those motions to dismiss or motions for demands of can of and by itself be the winning argument. Now, you file 30 of them so that you have 30 opportunities for victory. Don't ever go into court with less than 5 or 6 motions on key constitutional issues. And remember that those have to be filed before you go to trial, because after the trial is over with, you've already lost your appealable issues. And all of these constitutional rights have to be raised timely. Failure to demand a right waives the right. Failure to object timely is fatal. Now, those come from the Supreme Court of the United States. That isn't, Massa Gordon over here. That's the Supreme Court telling you that, not me. And so I'm just relating to you what it is you're going to have to do. Don't rely upon what the police tell you in the police station, because when you read Miranda, you'll find they give you false legal advice. I've had judges sit on the stand or sit on their bench and give me false legal advice. There are some judges that don't know the law. And if you get false legal advice, you can be cunningly coerced into waiving your rights. You don't listen to George Gordon. You don't listen to judges. You don't listen to prosecutors. You don't listen to lawyers. You get it from the horse's mouth. You go to the case. The highest court in the land is the Supreme Court. You get it from them first. If you get a case that comes from a state Supreme Court, well, then you get it from them second. If it's a federal district court, then you get it from them third. Actually, the third place would be the circuit courts of appeals, like our Ninth Circuit Court of Appeals in San Francisco. You get it from them. And then finally, when you get down to the Magistrates Court of the 3rd Judicial District of the state of Idaho, and they give you a judicial opinion, you use the term, Oliver Wendell Holmes, I know, and Chief Justice Jay and Marshall, I know, Fields, I know, McKenna, I know, but who is this Smith?